Welcome to today's program titled The State of AI Legislation. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, later in the presentation, we will read the CLE attendance verification code. Please write this code down, as it will not be reread and it is required on the CLE credit request form. During the program, you will see a slide with a QR code that you may scan to access and submit your request for CLE credit. You can also find a link to the form in the connection details email you received this morning. Copies of the webinar recording and materials will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw, LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Annette Timon. Annette, please go ahead.
Thank you so much, and welcome to everyone. Now that we got the initial announcements out of the way, we are ready to dive in, and we're really looking forward to the next hour, giving you some updates and sharing our insights on what is a very important topic these days, and it's the use of artificial intelligence and how states and regulations are dealing with those issues. I am thrilled to be joined by my fellow panelists today. First is Angie Evans, all the way from California. She is a partner in our LA office and does a lot of this work and is going to bring us some unique California insights. Rachel C. is an incredible team member on the People Analytics team. She brings a very unique perspective because she came to us directly from the EEOC, where she spent a lot of time working and thinking through the very issues, and so has a unique insight on artificial intelligence and how it's being used in the employment context. My name is Annette Timon. I'm a partner here in Chicago. I head up our People Analytics practice group, and artificial intelligence is one of the issues that we deal with as part of our team. So on the next slide, you will see our agenda and kind of where we're headed today. So we're going to spend a little bit of time talking about just general non-discrimination obligations under federal law and some of the themes that we're seeing there. But really the focus of this presentation is going to be what we're seeing in state enacted legislation or what we think is coming, because quite frankly, that's where we think a lot of the action is going to be going forward. So we'll spend some time talking about a summary of the enacted legislation, and really though what we want to spend time is on thinking about the substantive themes, right? It's one thing to talk about a specific state and what they're doing. It's another thing to think more broadly about the themes we're seeing overall, and that's really what we'd like to talk about today. We're going to talk about looking over the horizon, what the themes are coming up in 2025 and beyond, and then leave you with some key focus areas for those employers that are working on artificial intelligence issues generally. So with that, let's go ahead and hit our next slide. We're going to start with a brief overview of existing, non-discrimination obligations. On the next slide, we'll talk, and I'm going to let Rachel start here, talking about the general factors, like what's happening that's driving the AI legislation and regulation. And here we're talking about in the employment context.
Thanks, Annette. Hi, everyone. I'm pleased to be with you this afternoon talking about AI, which is, all AI all the time. That seems to be my life these days. And there's a reason for that. AI is really one of the issues of the moment, and lawmakers and advocates and employers and business leaders, I think, are all feeling those pressures. We're about, how long has it been since ChatGPT came out? And changed all of the things that ChatGPT and generative AI changed. And so we're seeing the increasing use of AI in the workplace, and we're seeing folks not just want to get more familiar and using AI of various forms, but the industry maturing and all these products that have come up in the HR field and elsewhere really start coming onto the market, and folks on the vendor side selling them and touting their benefits. That's driving fear and desires for competitiveness in the global economy. That I think that there are companies, there are business leaders who are seeing the lay of the land here, seeing what's going on, and saying, "Oh my gosh, we need to be using AI to remain competitive." And while all of that's happening, not just here in the U.S. but globally, we have international businesses adopting AI and international regulators seizing that moment, and of course fear about competition with China, both on an AI basis and all of the geopolitics that come with that. But Annette, why don't you talk a little bit about some of the concerns that we've heard in terms of discrimination and EEO risks also, because I think that's important too.
Absolutely. So that is one of the issues that practitioners are thinking about, legislators certainly are thinking about, and that is the issue of potential biases, right? AI, there's a promise, and that's the hope and the desire that it's going to make our jobs easier. It's going to have all these wonderful benefits, and yet at the same time, and we're talking about people and decisions about people, right? There is a nuance there we want to make sure that we are capturing and getting right, and there is a lot of concern, a lot of fear from employees in particular when you hear them talk about issues and how they might be facing potential biases in the workplace, from applicants, from advocates in general. And so that is a concern that, it's not just agencies that have concerns or legislators that have concerns about that. Employers themselves have concerns about this, right? They want fairness in the workplace. They want to have a robust talent pipeline that's coming through. But fairness is important. Efficiency is important. And all these issues coming together is really important. Another issue that we're seeing lots of questions around is a lot of the AI tools are focusing on worker monitoring, whether that's their performance or time, productivity, where they're at. And so that raises privacy concerns and, concerns around the location and tracking and monitoring employees. So all of those issues together are just pieces of the puzzles. We're seeing more and more use cases in the employment context and continued drives and questions from employers about how else can I use AI tools in the workplace.
And I think that some of these concerns fit nicely into existing laws and frameworks. Don't discriminate on the basis of race or gender, national origin, and others, like the privacy questions, don't fit neatly into those frameworks. And so we have lawmakers hearing that bias could be a problem, that people are concerned about bias and discrimination, and are also hearing concerns from the business community that putting in new regulations may somehow hamper global competitiveness or the American tech sector. So that's all creating all of these different pressures on lawmakers who are talking about both the benefits and the risks of AI. And they've been doing that for a couple of years now. So on the next slide, Angelina, why don't you talk about what we're seeing now in the HR sector and some very specific HR applications?
Yeah, so just to pick up where Rachel and Annette are going, SHRM conducted a state of the workplace research study. This was done in November of 2023, and it reported that 25% of HR departments were already using AI at that time. And also 26% reported that they plan to adopt AI in the future. So there's all sorts of evidence showing that the use of AI is happening now, and it's going to continue to grow. How are HR departments using it? Well, the top 3 uses that were reported in that study are recruiting. 64% of the folks that were already using AI were using it for recruiting purposes. Learning or training and development of employees, another 43% of HR professionals that are using AI were using it for that purpose. And as Annette alluded to, performance management, 25% of those HR departments that are using AI are using it for things like performance management. A smaller percentage of HR professionals that are using it for things like productivity monitoring, succession planning, and a very small percentage are using them for layoff or firing decisions and for promotion decisions. But there certainly is a push for HR departments to begin and continue using these tools because of the cost saving issues. There's also some support for using them to reach certain DEI goals, right? Which is, trying to diversify your workforce. And HR professionals have stated that in many cases, using these tools has made their organization's diversity and hiring, somewhat better or much better, as reported in that SHRM study.
And I think
So we're going to continue to see that increase.
Yeah, absolutely. I think that seeing these SHRM numbers, it creates pressures on both sides. It creates pressures on HR leaders and business leaders to innovate, feeling that, oh my gosh, my competitors, other people in my industry are doing this, so maybe I should be jumping in also. And you hear advocates and worker advocates seeing, the increased use of AI, and that's prompting greater concern and greater pressure on lawmakers. So on the next slide, some quick word about federal legislation and federal regulation. Again, President Biden talking about the great promise of AI, and just as recent as last week, we have Senator Markey introducing at the federal level a new bill called the AI Civil Rights Act that specifically targets employment, among many other things, employment decisions in AI. But one of our big perspectives here is that so far there have been no new federal laws that are specifically addressing employment decisions. So Angie, on the next slide, let's talk about the applicability of existing laws.
Absolutely. So even though there is no federal enacted AI law, it's been very clear in the guidance from all of these different agencies, the EEOC, the CFPB, the FTC, the DOL, the OFCCP, all of them are paying attention to the use of AI in employment in particular. And what they have continued to state is that they are going to continue to enforce existing anti-discrimination laws and Civil Rights Act when discrimination is carried out, whether it's done by an AI tool or not, right? So we need to just be mindful of the fact that these existing anti-discrimination laws still do apply. And if we move to the next slide, I think Rachel's going to give us some examples of federal enforcement of just that.
Absolutely. So the EEOC at the federal level has talked about actively enforcing our existing laws that look at the results of employment decisions, whether you make it with AI or if you're doing it with human processes. And so the EEOC has said that technology in hiring, that addressing discrimination caused by technology in hiring is a strategic enforcement priority. And they've issued technical assistance documents talking about how our existing laws, Title VII, the Americans with Disabilities Act, those existing laws apply to the results. We also have OFCCP digging in, and let's talk a little bit about OFCCP here.
Sure, absolutely. OFCCP is, as they audit federal contractors, the newest scheduling letter that came out late last year requires that employers or contractors submit and actually affirmatively state whether or not they are using artificial intelligence tools in their hiring processes. So it's part of the initial desk audit submission without any findings of adverse impact, any results, nothing. It's just the agency wants to know the extent to which the employer, their hiring process generally, and then very specifically whether or not they are using artificial intelligence. In addition, the Department of Labor issued some promising practices that really mostly apply or contractors are considering, but it's actually a very helpful, I think, resource tool for all employers to be thinking about, because these are the kinds of issues the agencies are going to be evaluating employers on. Now, it's not binding on anyone, but these are helpful guidance materials around what the Department of Labor and the OFCCP would believe to be a promising practice. So if you have issues in the workforce and you're looking through and adopting those promising practices, I think that's going to be helpful to you going forward. It includes all kinds of things like transparency, engaging in fairness assessments, monitoring, which we're going to talk about a bit more. And as we lead into the next slide, those promising practices, really, if you start thinking about it and kind of where we're headed, and that's what we want to be focusing today, is really thinking about this traditional framework, where it looks at, as Rachel mentioned, sort of the end result, right? What happened? Is there some sort of evidence of adverse impact or disparate treatment against individuals? And if there is, in the case of disparate impact, do you have validation in the tools that you're using? Whatever kind of assessments, and those, through the uniform guidelines on employee selection procedures has been in place for years and years and years. It's nothing new here, and so what we're doing is thinking about implementing those guidance materials into the traditional framework. That being said, what we're seeing now is this shift. And that shift in framework is not just, let's look at the end result. It's actually, let's focus on the process, right? What is it that developers or deployers, employers who are using it in our context, what are you doing about the process itself in the implementation phase and throughout the entire process? So it's not just a one and done, I've got the tool, I tested it, it's good to go, we move forward. It's this constant and ongoing obligation, and that's what we're seeing come through. As we go on to the next slide, we'll see that a lot of this, if you haven't spent any time with the NIST management framework, that I would encourage you to do so. This is a tool, a comprehensive set of materials that the agencies are coming out with and they're using and they're aligning on their own. It has been used by employers who are thinking through about how to develop it, and what it essentially is sort of a formalized structure around how you can engage in risk mitigation strategies when it comes to artificial intelligence tools, right? How do you think about the process itself, the tools? How are you going to measure it? How are you going to assess any potential risks, and really thinking through how to do that in any context that you're looking at? For us, we're talking about the risk management context, and really thinking about how to mitigate those risks. It is a robust process and kind of a framework through which employers can implement their tools and their strategies. And the interesting point is that we are seeing many of the states begin to move in that direction, and we're starting to see themes come through these areas that are really grounded in the NIST framework. So by using the framework, employers can really think through how they mitigate risk, and that involves all kinds of issues like bias, which we talk a lot about, ethical concerns, security concerns, what happens if there's a fail of the system, how is data protected? Those are all considerations that employers and deployers should be thinking about as they move forward. And so as we'll see in the upcoming materials, we're starting to see those themes carry through. So Rachel, why don't you take us into state legislation issues?
Absolutely. So, there's a lot coming out of the federal government. As we talked about here for almost 20 minutes, there's all of this stuff coming out of the federal government, and we have these overarching federal non-discrimination obligations that the EEOC says that they're looking to litigate, they're looking to enforce. But without having new federal laws or clarity on that, I feel that the state legislatures are sensing this pressure. Let's go to the next slide. Sensing the need for filling a perceived gap here and wanting to jump in. So when we say there's been only a few states that have passed new laws about AI, that's specifically about employment processes, using AI for employment processes. We could spend over an hour with a totally new webinar talking about recent AI legislation, just AI legislation passed or not passed last week on deepfakes, on watermarking generative AI content, on AI safety testing. That's California SB 1047, which had a lot of controversy, which the governor vetoed. But all of that, those are a little different than the very specific and focused bills, some of the focused bills that we're seeing where the states are trying to fill a gap specifically on AI in employment. So that's why we're going to focus on the two states that have passed these employment specific bills this year, Colorado and Illinois. We'll mention briefly New York City, as well as some of the ones that almost passed, and that's where California comes in. So we'll spend a little time going through the procedural side of exactly what bills are we talking about in broad strokes of what they did, but then spend the bulk of our hour here talking about the substantive themes in there. Okay, so on the next slide, let's talk about the big one, and that's Colorado. So Colorado was enacted in the spring, and so we say that's the first state to have broad legislation regulating AI usage. There's no private right of action on Colorado's AI law. That's reserved to the Attorney General, to the Colorado Attorney General. But remember, there's those underlying non-discrimination obligations under both federal and state law. Now, one of the odd things, or one of the unusual things about this comprehensive AI bill enacted in Colorado is that when the Colorado governor signed the bill, he issued some cautionary language, saying it's like, with reluctance. He's acknowledging that this is a complex compliance regime. And he didn't like it, but he's signing it anyway. And then a couple of weeks after the governor signs it, the governor, the attorney general, and the bill's primary sponsor issued a press release saying that, oh, wait a second, we're all committing to revise the law that we just enacted to minimize unintended consequences before it goes into effect in February 2026. Scant comfort for those seeking clarity on what's actually required in Colorado and how that might change. But I think that's quite significant that whatever momentum and pressure they had to pass and enact that bill, the pressure on from the business community saying, wait a second, are you really sure? Think about all the ways this affects Colorado businesses and innovation and the use of AI in that state that causes them to say, oh, wait, no, we'll revisit. So however broad Colorado was, we have on the next slide, let's talk about Illinois, which is narrow, which is narrow in its scope. Annette?
Yeah. So Illinois is quite narrow, as Rachel mentioned. The requirements, it was just passed August 9th of 2024. The requirements are not going to go into effect until January of 2026. But really, the distinction is that here employers are going to be required in Illinois to notify employees if they are using AI for employment decisions. I would say that's the biggest change. It's the notification, it's the transparency that we're seeing in other states. Illinois is adopting that and making it a requirement for employers in Illinois that are using these tools. In addition, it sort of expanded, or I shouldn't say expanded, it clarified, made clear, affirmed that it's unlawful for an employer to use AI to discriminate, which is frankly something that we've always said, right? On the federal side, the EOC has taken the position, hey, nothing new here. If you are using any tool, doesn't matter whether it's an individual making decisions or you have, automated employment decisions or other sort of tools, AI tools that are making decisions, if you're discriminating, if you're bringing in bias into the workplace, it's going to be unlawful, right? So it is interesting that Illinois felt it was necessary to affirm and to state that the AI tools essentially it's unlawful to discriminate on that basis. In addition, it sort of kind of expanded the requirements because it's bringing into account that it's covering all of the same protected categories. We are waiting for regulations, rules from the IDHR. They're going to be responsible for providing additional guidance, rules around enforcement and implementation. So that is going to be coming hopefully soon, but certainly before implementation. And with that one, I guess we can talk about New York City as well on the next slide. So we all know this one is probably New York City Local Law 144 was passed in 2022 and enforcement began back in July of 2023. It really received a lot of criticism because it was believed that, frankly, the tool, at first glance, there was a lot of concern about it, but when you're really looking at it, the tool or the law really applies only to those tools that substantially assist or replace decision-making. It did require employers to have independent bias audits and to publish the results of those bias results and the audits that they were implementing. So it's really interesting because here what we're seeing is if the law applied to a specific tool that was being used by an employer, there was this requirement. Again, we're seeing assessments or audits that are being required, as well as a level of notice or transparency that's coming through that we'll continue to talk about as we move through the requirements. Rachel's now going to chat with us about Connecticut and what happened in Connecticut on laws that did not pass on the next slide.
Absolutely. And we will be returning to bias audits and impact assessments and what all of these bills, these past bills are trying to do later on. But we wanted to give you all a taste of the complexity of what's going on in the different states and just the lay of the land here. So earlier this year, Connecticut almost passed. The bill made it out of the Senate and the Connecticut Senate and then died in the House when the Connecticut governor, a Democrat, announced that he would veto it if it went further. I think he viewed it as bad for business. So Connecticut was one of the had early momentum at the start of the year, and it wasn't just an employment bill. It was really a kitchen sink bill trying to do a bunch of things on deep fakes, on disclosures, on broad-based things, and I think many of those concepts were taken up by other states. Importantly, the primary sponsor of the bill, Senator Maroney, has vowed that he's going to be back with another AI attempt next year. He's been saying that for months. That's not new news, but it was reported last week that he is part of a working group with lawmakers from 46 other states to develop AI standards. I think that we had known through various sources that there was an informal state legislative working group, but 46 other states, I think that's a slightly new piece of information. And of course, let's go back to Angelina on the next slide to talk about the almost passed, the very significant almost passed legislation specific to employment on California. That's AB 2930.
Yeah, so this is actually California's second time trying to get a bill like this through. It got very close this year, but ultimately died on August 31st, which was the last day of the session. That bill, there was the issue is that there was some back and forth between who is going to be the enforcement agency to actually do the enforcing. Is it going to be the Civil Rights Department? Is it going to be the California Privacy Protection Agency, who has its own set of regulations that are also coming out and in draft form? But ultimately, the bill also underwent some significant changes that started out as a kitchen sink type bill, like the Connecticut bill that Rachel was just talking about. But towards the end, it was narrowed down to really focus on consequential decision making, or AI tools that apply to consequential decision makings for employment only, and that includes pay and promotion, hiring and termination, and other automated tasks that limit or segregate or classify employees for the purpose of assigning material terms of their employment. So the law was broken down between certain requirements that deployers have to reach, and those are the employers, and certain requirements that developers have to reach. So those are the folks that create the tool themselves. Similar to the laws that were enacted, specifically in Colorado, there were impact assessment requirements before those tools could even be used. Advance notice to affected individuals. The opportunity to opt out was also written into the law in one of its nuances, and a governance program that needed to be established that had some sort of human oversight as part of the process. Again, there was no private right of action, so enforcement was really just going to be done by whatever agency ultimately was assigned to enforce it. The law, as it ended, had it as the Civil Rights Department, and there was an opportunity to cure any sort of issue that was found based on the impact assessments that are provided, but ultimately it didn't make it through. But I do believe, and there certainly is going to be a lot of movement on this as we move forward, either from something similar that will be enforced by the Civil Rights Department or the CCPA.
Yeah, and Annette, before we move on from California and the
Sure.
procedural side of things, one of the things that I think is really of a moment in California is the state budget crisis. And I think one of the things that really derailed 2930 is our questions about, well, what will this bill actually cost? Not just for California businesses facing compliance and enforcement, but what will it cost for the state to enforce? And what kind of unfunded mandate on all of this extra enforcement is being foisted or being requested by CCRC or any other agency? It started as this kitchen sink bill that included these provisions that California's state agencies are essentially going to do risk management practices like the NIST risk management framework, and someone said, oh no, wait a second, we can't do that because of all of the costs that would impose on the California government during a budget crisis, so please take that out. And all of these things started coming in and out, and the budget and the compliance costs came back in a very interesting way there. But with all of those caveats, they've said they'll be back also. So let's jump ahead 2 slides, and Annette, why don't you give us a high-level summary of some of these themes that we're seeing?
Yeah. So we as we were thinking through how to best present some of the materials and just how we've been thinking about the either regulations or the laws that we're seeing come through, including those that have been introduced but maybe haven't been passed, we started to see these themes emerge. And for us, right, scope, risk management, impact assessment, the transparency, accommodations, and enforcement are I would say, big buckets, right, that we can see themes woven into the various regulations and or laws that are being proposed or passed, right? So when it comes to scope, right, sometimes there's protections beyond what federal law would provide. Risk management, it's a formalizing, right? Something going deeper and really formalizing how you are thinking about risk. Assessments, we're going to talk a lot about assessments today. Transparency, not just for employees, but sometimes to the public, right? What you're using, sharing impact assessments with a particular state agency. Talking about accommodations and how individuals with disabilities should be, you're considering their specific needs and opt-outs. And then finally, enforcement, right? That is really, many of the states are trying to think through that, and they all take a unique approach when it comes to the issues. And so on the next slide, let's talk about scope. So I started talking about Illinois, right, and how, they really just formalized that it applies, right? It supplements their existing non-discrimination obligations. In Illinois, they specifically called it out and said, hey, AI tools apply here, right? Colorado as well. And Illinois, right, one of the issues is that it is making it broader. And I alluded to that in one of the earlier slides when I was talking about Illinois, but it says AI tools, it applies, and how you're using it applies to all protected classes under the Illinois Human Rights Act. Well, some of the categories that are protected under the Illinois Human Rights Act are not just what many people are focused on, race, ethnicity, and gender, but it also includes military status, order of protection, family responsibilities, conviction records, arrest records, like all of these issues come to play, and the extent to which some of these laws are enhancing or expanding some of the considerations that employers have as they think about state AI laws is something that we should be mindful of as you move forward. So Rachel, why don't you talk through a little bit more about New York City and Colorado and others?
Sure. So the other way to think about scope, and let's go to the next slide, is that these state and local laws have very different definitions and very different reaches. So I think one of the criticisms of New York City Local Law 144 was that it was too narrow, or that folks, that employers were interpreting the kind of tools that it reached narrowly. So we have in Colorado SB 205 Colorado applies to consequential decisions, and that is a term that I think the legislators attempted to define. We saw that in multiple bills introduced this past season, this past legislative season, saying that consequential decision has a material, legal, or similarly significant effect on terms and conditions of employment. We don't see that qualification of consequential decision in the Illinois law. The Illinois law, there is no qualification in the statutory text. It's literally any application, any AI application that an employer is using it for all of the processes, for all of these employment processes, falls into, not just the underlying non-discrimination requirement, but also the notification requirement. So there's questions about, well, if you use AI for something that's not a consequential decision, what are your obligations here? How is IDHR going to address that push and pull? Those clarifying regulations may or may not give clarity, and where they choose to stick out their neck, or how that rulemaking process comes develops over the next year. We will be monitoring closely. I should also mention, in terms of, from narrow, on the slide here, we have this sort of setup from narrow to broad. And so in addition to the legislation that in California that did not pass, so AB 2930 did not pass, there is proposed rulemaking from the California Civil Rights Council, part of the Civil Rights Division. So CCRC, part of CRT, all the acronyms, right? So CCRC's proposed regulation, their definition of AI just goes, in its practical, as you extend it practically, makes a decision or facilitates human decision making that impacts applicants. So from consequential decision all the way down to something that impacts applicants or employees, we get narrow to broad. So just because someone's not under New York City, that says nothing about the scope of where you might be on other issues. Okay, developers and employers. Annette, let's go to the next slide, and let's talk about developers.
Yeah, before I dive in on this one, I saw a question come through the chat, and it was very tied into some of the issues you were just talking about, Rachel. And I think the question had to do with, is there a distinction between generative AI and automated review processes, using large language models, perhaps to filter through resumes, to match resumes. And, you really need to look at the text, the specific state requirement. So in the one that Rachel mentioned in California and what's being proposed, that might fall within that concept. So you really do have to look at the tool itself, how it's being used, and then apply it to each and every state or jurisdiction or regulation that we're talking about, because they are very, very different, which creates significant challenges. It is complex for employers and deployers to think about. But that is, you know, we don't have a easy answer to say, oh, that's automatically out, for example. You really have to look at it. So with that, we're going to continue on with the scope considerations. And one of the really interesting things in Colorado, as well as the bills that almost passed in Connecticut and California, is these separate disclosure obligations between the AI developers themselves, those that are either creating or modifying substantially the AI systems, as well as the deployers, right? Who's using them? It might be an employer that's actually implementing the tool. And the interesting piece, especially in Colorado, is these, you know, that the AI developer has certain obligations and is required to now disclose to the deployer, right? What is the intended use and how the deployer or the developer should have, or, you know, created that tool to be developed, as well as known harmful use cases, right? So it's basically telling you, hey, this is how we intended this to be created, and be careful because there's something that could go awry here because we're aware of that, right? They're required to disclose the data types that are used in training and any known limitations or risks, which is really interesting that Colorado, at least at this point, has this enacted, as well as evaluation methods for to mitigate against potential biases. And then the deployer also has its own obligations to provide notifications and transparency and disclosures to consumers, right, which is going to be to the public, to applicants, in the case of employment, and then to engage in some data correction and appeals processes and have processes in place. But Rachel, why don't you expand a bit more on those concepts?
Absolutely. And, you know, I think the distinction between AI developers and deployers came out of the business community. You know, it has a lot of, it's rooted in the market and the reality of how these tools are being used, you know, by HR professionals and in other industries. But then you get some of these additions into the law that don't make sense or might not make sense. So for instance, in Colorado, there is the Colorado law gives consumers, gives, you know, job applicants the right to correct data. And how does that actually work when you have a deployer to a developer? You know, who's doing the correction? How does that even work? And that's one of the areas where the sponsor of the bill and the governor and the AG said, oh right, yeah, no, we're going to clarify what that means, and our press release, we think it means something totally different than the statutory text. But in the meanwhile, we have the statutory text. Okay, risk management, and you want to talk about risk management?
Sure, I'll get started here. So
Yeah.
one of the key areas is on the risk management framework is that, you know, there's state laws, including Colorado, and well, I think we need to go to the next slide here. Sorry about that. Colorado's law, right, has a unique feature, right? And it says, hey, if it's going to allow employers that used reasonable care in setting up their risk management framework, a presumption, a rebuttable presumption of compliance, if they've demonstrated that they've had some compliance with some sort of framework. So they say, for example, one of the frameworks that you can show that you've used reasonable care is the NIST AI risk management framework that we talked about in the beginning of the process, right? It is a rebuttable presumption that employers can do and demonstrate, developers as well, that they can demonstrate that they've done the work necessary to ensure that they are mitigating risk, that they're aware of risk implications that are associated with the use of their tools, that they are thinking through what those steps are. And that can include all kinds of things by taking, such as taking proactive measures to engage in, you know, user feedback, what's happening, to implement things called adversarial testing, right? Feeding it incorrect inputs to understand what's actually happening if you're starting to feed it incorrect inputs. Is it going, you know, just in a totally different direction? how the tools actually should be used, which is why the information from the deployer, from the developer to the deployer is so important. This is how we intend this particular tool to be used. And sort of describing the use cases. Another concept is red teaming, which, is sort of an independent group that basically you say, hey, here's our tool, break it, do what you have to do, kind of crack the code and let's see what happens. And all of that is part of some of the proactive measures and proactive steps that would be seen to be, demonstrating that you are engaging in reasonable care from a risk mitigation perspective. And so there's these incentives to do that. There were similar concepts in Connecticut and other legislations, but obviously those didn't pass through. But we do anticipate that we will be seeing that, which is why looking at the risk management framework that NIST has put out is really important. Rachel, do you want to add anything there?
Yes, of course, just because you have an affirmative defense in SB 205 to your duty of reasonable care, that's not an affirmative defense to underlying non-discrimination obligations under federal law. So you have this interaction of, it's like, oh, there's a rebuttable presumption, there's an affirmative defense that's written into the Colorado law. Yay, that's good. That gives people something to hang their hats on. And it's also, don't forget your underlying non-discrimination obligations. I feel we're running a bit behind schedule here, so let's
go ahead. Go ahead, Rachel.
So let's skip ahead. Impact assessments. So please do not get impact assessments required by Colorado SB 205 or any other law confused with the bias audit as defined by New York City Local Law 144. They can be very different in scope, and I think there's this ongoing notion of, it's like, well, we're going to have people now doing impact assessments instead of bias audits. What does that mean? That's probably another 1-hour webinar that we have. Note that the impact assessment must be performed and must be disclosed to the Colorado State Attorney General upon request. So that takes me to disclosures. Let's go to the next slide, please. Again, impact assessment. Yes, so we also have impact assessments under the EU AI Act. So I think our colleagues dealing with the EU and under EU law will be probably leading the charge on helping get to consensus, on clarity on what goes into an impact assessment, with people perhaps poking at it. And of course, if we look at those underlying federal validation requirements under the uniform guidelines and elsewhere, we have leaders from the federal government, acting OFCCP Director Hodge, saying it's like, yeah, you got to validate, you got to do this testing, you got to measure, you can't just pull something off of the shelf. And so that's not a new concept, even though the laws are requiring it. Okay, let's go on to the next slide. And one more, please, since I've jumped ahead a little bit. So Angelina, quickly, let's talk about disability accommodations.
Yeah, accommodations, and this really does go hand in hand with the slide that we just went past about transparency and disclosures, because what the guidance is saying is that we really need to be thinking about the potential for unintentional discrimination, right? Because when we're talking about things like accommodations for disabilities, there is no one size fits all for an accommodation, right? So what the EEOC and what the guidance is telling you is that, look, you need to make sure that the tools that you're using are closely tied to the job function that's going to be held, and you need to have disclosures and transparency, because if someone who might require an accommodation has no idea what data is being looked at, what's being used, what's being tested, they have no idea that they need to even request an accommodation. An example of this is, say you're doing a video interview for a job, and you're answering questions with a bot or a AI tool, and in the background, a personality test is being run, right, based on your answers. Well, someone who may be neurodivergent or on the spectrum of neurodivergence may not know that those types of tests are being run in the background, and may not do as well as someone who does not have that type of disability. And so what the guidance is all saying is, make the disclosure, tell clearly what is being assessed, and give people an opportunity to opt out or request an accommodation if they need one. And the next slide is about enforcement. We actually already touched on this. Rachel has hit it. It really, this is just, again, repeating that there is a private right of, there's no private right of action, but certainly underlying anti-discrimination laws are going to apply. So if you're not complying with the notice requirements, you may still have an issue if your tool ended up screening out somebody unintentionally and caused a discriminatory effect to someone who's in a protected class. So let's go ahead on to the next one. And I think
yeah, so let's
Rachel, yeah.
take a peek over the horizon. Next slide, please. So we have Colorado and Illinois passing employment-specific bills in 2024. It will be a very busy legislative season next year. The first out the gate, perhaps oddly, will be Texas. So Texas's legislative season will start at the end of the year, and there's we anticipate hearings and action from Texas to get something on the books. Besides that, towards the beginning of 2025, Colorado, they've announced their intention to revisit the law to minimize unintended consequences. We know Connecticut and California are raring to go. There's New York legislators also saying they want a further crack at this, and it is a very, very busy space here. Stay tuned. Substantively, let's talk about California taking the focus. So Angelina, let's go to the next slide and talk a little bit about that.
Yeah, so what I want to, I'm actually going to talk about this a little bit out of order, because the Reigns versus US HealthWorks Medical Group, it's not an AI case, but it does have implications on developers of AI tools. And the reason for that is because the Reigns case was a class action that was brought by two plaintiffs who had applied for a position with an employer. And in order to get the job, they needed to go through this this pre-employment health screening that was conducted by a third party, and that's the defendant, the named defendant there in the case. Well, the employer settled out of the case and was dismissed, but then the only party that's left in the case of defendant is this healthcare screening company. And their main argument in trying to dismiss the case is like, we are not an employer. We can't discriminate under the FEHA. You have to be an employer to discriminate under the FEHA. And the court completely rejected that. This is the California Supreme Court. They said, look, if you are acting as an agent of an employer and you're taking on, employment-like functions, meaning your screening of this person is going to have an impact on whether they get the job, then you might be liable for discrimination under the FEHA. And the reason I talk about that first is because we see then the California Civil Rights Council now trying to work into the new laws, the very clear joint and several liability between both employers and quote unquote agents of employers, which would include AI developers and tools like that. We then saw in the Mobley class action that was filed in filed in 2024, or excuse me, 2023, and the EEOC and also filing an amicus brief supporting that same argument on behalf of the plaintiff that, look, Workday, even though they are a company that's helping with employment-like functions, recruiting and screening of candidates and things like that, they should still be liable for discrimination under the FEHA. And the court allowed the case to move forward. It's still pending in the Northern District of California under an agency theory. So, what the takeaway from this is that whether you are an employer or someone who's creating these AI tools for use, you do need to be paying attention to these types of things in California, because the definition of agent is going to very likely include developers of these tools as well. And you could be, those developers of those tools could certainly be liable jointly and severally with employers for engaging in discriminatory action to the extent that those tools have an adverse impact on certain groups of protected protected people.
Cool.
And
Angelina, are we ready for the CLE?
Oh, yes, we are.
Okay, cool.
CLE slide.
Yeah, thank you. So our CLE code is SS, as in Seyfarth Shaw, SS2010. Again, that's SS2010. I'll leave it up for a bit. You don't need to scan the QR code. We'll send that link out with the email, and we will be sending out a copy of our slides along with a link to the recording over here. So let me talk about what employers should be thinking about, or what our advice, big picture wise, has been to employers. In the wake of all of this complexity between state and federal, and some of the lack of clarity on where where things are headed. So let's get back to the basics. So as in-house counsel, or as an HR professional or a compliance professional looking at this, part of the real need here is to understand what's going on in the business. So let's jump ahead to the slides, two slides, please. Thank you. So how is the business, how is the employer using AI? What level of transparency do you have with what vendors? That are your HR people just asking ChatGPT for advice? Are they acting on ChatGPT's advice? If they are, please call your counsel. But beyond that, what other AI service providers have been contracted? What's the testing? What's the monitoring? That if you all are using an AI product in the employment process to begin with, what is the vendor? What is the tool? And what has been done? So understand that disclosure, like we see in Illinois, like we've seen in multiple legislative proposals, disclosure is in the future. And even business groups have talked about disclosure to employees, disclosure to candidates. Some have talked about that as a best practice. And so if you're not disclosing the use of AI, and you're not collecting those opt-ins, even though not strictly required by federal law, and still inchoate under many, all of these state frameworks, consider whether that disclosure, or think about how that fits in, especially globally, especially if you're a global employer that has to do this for GDPR, or has to do this for other international obligations. How are you handling that? And how do you feel about that disclosure? Also understand that when you're talking about testing for bias or impact, whether we call it a bias audit, an impact assessment, a risk and assessment, a fundamental rights assessment, any of these terms, understand that these are probably disclosable. In Colorado, employers, developers and deployers, you must conduct this impact assessment, and you must disclose to the Colorado State Attorney General upon request. With caveats, but upon request. So how do you feel about disclosure of your testing processes and of your testing results? And what does that do for your exposure to private rights of action or further enforcement under the underlying non-discrimination statutes? Lastly, next slide. If you're just thinking about using AI, or if you're earlier on in your journey on this, I start with, well, wait a second, what benefits are you seeking to capture? I remember, back when I was on more on the business side of things, and there was a feature that one of our vendors pushed out on us that seemed kind of neat, but then we call it, it's like, wait a second, why do we actually need this? Why do we actually need this kind of shiny, kind of spiffy feature that also comes with some risks, comes with some disability accommodation dynamics? What benefits are we trying to get out of it? And again, going back to NIST, going back to NIST and the AI risk management framework, measure, have your processes, but identify and measure how the AI could go wrong, and understand that when, if the AI has risks, that's going to come both from technical risks and also your people and how you use the technical systems. And also don't forget the disabilities and all, people with disabilities and all of these other very dynamic civil rights issues, and non-discrimination obligations. With that, I think we have a minute left. Annette, I will give you the last word.
All right. Well, I mean, needless to say, the issues are complex, right? There is a lot involved here. We're continuing to track these issues. Bills get introduced pretty quickly. We hope that by presenting these themes to you, you can start thinking ahead of some of the implications. We anticipate that it's going to be more of the same. States are certainly have a desire to push forward. Litigation is likely coming soon, and we are certainly anticipating that. So feel free to reach out to us or anybody that you work with here at Seyfarth. We hope that this presentation was helpful to you as you continue to think about the use of AI in your workplace. Thank you so much for attending.